You're on probation. You got to do the classes.
Yes, ma'am.
If you don't do the classes, what's going to end up happening is a motion to revoke is going to be filed and you may be at the prison. And they don't allow children at the prison. They don't allow the children at the Bexar County Jail. You understand?
Yes, ma'am.
So who helps you with your children?
Currently right now, nobody.
Where's your mom?
I don't know, probably at home or working.
All right. So do you trust your mom to babysit? That's either yes or no.
No,
All right. Who do you trust to babysit?
nobody. I had my kids in daycare, but I had to take them out.
All right. So you're on probation.
Mhm.
You must do the classes. If you do not do the classes, what's going to end up happening is a motion to revoke is going to be filed. If it's in proper order, I'm going to sign it. And then the police are going to come pick you up wherever you may be. If you're at your house, they're going to come pick you at your house. They'll call Child Protective Services to come pick up your children. Or if you have a relative who will come, they will do that. Right. So, Ms. Garcia, these are the issues with you. And I understand that people have issues in their life. And I understand that you have children, but you're on probation. You got to do the classes.
Yes, ma'am.
If you don't do the classes, what's going to end up happening is a motion to revoke is going to be filed and you may be at the prison. And they don't allow children at the prison. They don't allow the children at the Bexar County Jail. You understand?
Yes, ma'am.
So who helps you with your children?
Currently right now, nobody.
Where's your mom?
I don't know, probably at home or working.
All right. So do you trust your mom to babysit? That's either yes or no.
No,
All right. Who do you trust to babysit?
nobody. I had my kids in daycare, but I had to take them out.
All right. So you're on probation.
Mhm.
You must do the classes. If you do not do the classes, what's going to end up happening is a motion to revoke is going to be filed. If it's in proper order, I'm going to sign it. And then the police are going to come pick you up wherever you may be. If you're at your house, they're going to come pick you at your house. They'll call Child Protective Services to come pick up your children. Or if you have a relative who will come, they will do that. If you are driving them to school and you're in the carpool lane, they will pick you up there. And that's what's going to happen. And you have to pay restitution. This is a theft case. Am I looking at the wrong case?
No, Your Honor.
Yeah. So you owe $1,490 in restitution.
No, Your Honor, I apologize. That's the amount that she's paid.
Okay.
She still owes the balance of $775.
All right, you owe $775 in restitution. When you commit a theft, people want their money. Or when you commit, in your case, a criminal mischief, which is destroying or defacing a property, they want their money. And I understand that people have life and things that are going on in their life, but don't commit a crime and you won't have to do these classes. So if you do not do these classes, if you do not register, because I see it says she has failed to register and take either of her classes. You have parenting classes, you have anger management classes. So you say you take care of your children. How are you financially supporting yourself?
My kid's father helps me right now.
All right. So do you trust him to babysit?
Yes.
Yeah. So you need to do these classes. You need to do your parenting classes. You need to do your anger management classes, and you need to pay the $775. Do you understand?
Yes, ma'am.
If you do not do that, you know what's going to end up happening? A motion to revoke is going to be filed. If you take your time in paying this $775, you know what's going to end up happening? Your probation is going to be extended.
Yes, ma'am.
So if you don't want any of those things to happen, you need to get registered in class and you need to take those classes. Do you understand?
Yes, ma'am.
All right, probation, when do you want her registered in the classes?
Your Honor, if we can give her 10 days to show registration at least.
Okay.
The other issue is her probation expires on the 21st of this month.
Oh, you're going to be extended.
Yes.
You're going to be extended for a year. If you complete everything before then maybe the court will consider terminating you early, which would be you're done. All right. So we'll extend her for a year and you have 10 days to register for those classes. If you do not, if she does not register for those classes, then file a motion to revoke. Is there anything else you need?
No, ma'am.
All right. Thank you. Probation. Is there anything else?
No, Your Honor.
All right. Thank you. Who's here on David Quint? Join us. Thank you. All right. All right, do we have the communications between the complainant and the defendant? That's what we were here for last time. CPS records were outstanding, and this was in May, so I gave you all till July. So CPS records and communications between the complainant and the defendant needed.
I know that Victoria Cruz said she signed the discovery acknowledgement, but as to those specific discovery issues, I can't attest, Your Honor.
All right, Ms. Ferguson, recall this for the 13th. And Ms. Ferguson will give you a reset form. And on that day, you ought to need to let me know what's the update on the communications between the complainant and the defendant.
I will.
All right, thank
Your
you. Ms. Ferguson will give you a reset form, then you're excused. All right, the next person is Laura Romero. Is the attorney here for Laura Romero?
Yes,
All right, if you come forward. And counsel, your client was late, so let him know that he cannot be late for the next hearing.
Okay, Your Honor.
All right, yes. So we're here for jury trial. So if you all will come back at 1:30 and we'll take that up.
Very good. Then.
All right, thank you. Demario Jones. Who's here for Demario Jones? All right, are you all ready to proceed?
Yes.
Court is calling 2019 CR 7581 State of Texas versus Demario Jones. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Carl Basil, Your Honor.
And are you Demario Jones? All right, I'm going to show you what's entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Demario Jones who's placed on community supervision in 2019 CR 7581 for the offense of assault, bodily injury, family household on October 31st, 2019 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Yes, in violation of condition number 2, on or about the 9th day of December 2019 in Bexar County, Texas, the defendant, Demario Jones, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, at this time, we'll waive and abandon the remaining violations.
Any objections?
No objections, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to a $4,000 fine and up to 1 year in the Bexar County Jail?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
Your Honor, I believe there's an agreement to revocation. However, the state is requesting the underlying 1 year. And I believe defense is going to request the court to reform that.
That's
All
correct,
right.
Your
So the state is requesting 1 year. Defense, what are you requesting?
Honor, I would request the court to reform the judgment. I'm not trying to make any excuses for my client. He didn't, well, he did do some drug testing. It was negative, and he did do some others. It's because he was working and he was gone. The court knows from the supplemental. But as the court can also see, he did not pick up any new offenses. He's been out 2.5 years working, raising his family. And it's not an excuse, Your Honor. Just let the court know that he's been trying to do right, except for he should have been reporting. He's telling me his mother is in Florida. She recently, within the last year, has been diagnosed with cancer and was wanting to go visit her and wants to get back to work as soon as possible. So he can make money to do that. So he will visit her. And I'm asking for the reform of judgment. I'd like to see the court reform it. He has 103 days credit at this time, Your Honor. If the court could reform it to 206 days or somewhere around there, they can that, or if not, maybe a 30-day jail sanction. So he understands that he did do something wrong. on that.
So what did he do while he's been on probation?
He's been,
Did he do the class?
he started some classes and he did not finish the classes.
All right.
He did do some testing and was negative on, he was positive on the first test, I think, when the first one, and everyone after that he did was negative, but he did not show up on some other.
All right. Any objection to the court reviewing the court summary, probation's court summary?
No,
All right. So what I see here is he was exited from the Battering Intervention and Prevention Program on October 20th, 2020. He was given an opportunity to re-enroll in the class, and then he was unsuccessfully discharged on February 8th, 2021. He hasn't done parenting classes. Have you done parenting classes?
no.
So he hasn't done anything. All right. Is there anything else from either side?
No,
Your Honor.
that's my client. What do you want to say anything?
Okay. All right. This is what the court is going to do. The court will grant the motion. Court is going to sentence you to 1 year in the Bexar County Jail. There's an affirmative finding of family violence. There's to be no contact with Leanna, Leighana Gonzalez, Gonzalez. Give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, good luck to you. Do better, okay? Who's here on Cruz Rivas? And is there just a plea on one case?
Yes, Judge.
Okay. Court is calling 2022 CR 6937, State of Texas versus Cruz Rivas. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Guillermo Lara for Mr. Rivas, Your Honor.
are you Cruz Rivas?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Judge, we have.
Court will find that the state is in compliance with discovery. Is there no applications?
No, Your Honor, there's not.
Mr. Rivas, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Rivas, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
You understand you're charged with burglary of a building with intent to commit theft. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Rivas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm going to show you the plea bargain page. Thank you. Did you review this page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 14 months in the state jail facility. and the state will take in consideration 2022 CR 8522. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That's correct, Judge.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
I'm sorry, Judge.
Have there been any such motions?
No, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State offered State's Exhibit 1 in all attachments.
No objections.
All right, you may continue to defer. Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Your Honor, other than we ask for any time that he's been in custody to be credited to his sentence, Your Honor.
All right. The court will follow your agreement. The court will sentence you to 14 months in the state jail facility. The court will give you credit for any time served. Take in consideration 2022 CR 8522. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have an issue or question about what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. How old are you?
37.
All right, you're going to have to do better. If you have a mental health issue or going through a mental health crisis, or if there's a drug issue, there are plenty of free places in San Antonio to help you, okay?
Okay.
All right, good luck to you. And I
you.
want to let you know that I do receive all the letters from the jail. I don't read them until I've had the defense attorney read them, okay?
Yeah.
So, all right, thank
Thank
you.
you, Judge.
Who's here on Tyler Small?
I don't know.
I'm going to check. I think there's an arson case. An assault on a public servant. That's Lionel Young. If you'll let Ms. Ferguson know, she'll call that attorney. Oh, okay. I'm going to take you up right after this. Court is calling 2023 CR 0029, State of Texas versus Tyler Small. Could I have parties announced for the record for the state
Ruben for the state.
defense?
Attorney Albert Osvaldo for Mr. Smalls.
And are you Mr. Small?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Small, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right, Mr. Small, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of injury to a child intentionally or knowingly? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Small, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. The state is remaining silent on your application for deferred adjudication. They recommend community supervision. They will take in consideration grand jury number 77329, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your
Did you understand that to be the entirety of your agreement?
Honor. Yes, Your
State,
Honor. Yes, Your Honor.
defense?
Yes, Your Honor.
I've been doing that lately. All right, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your
Counsel, are there any such motions?
Honor. Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your supervision be for a term of 6 years. There'll be a TAP evaluation. No unsupervised contact with the complainant. No harmful or injurious contact with April. Parenting classes, random UAs, and the BIPP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State out for State's Exhibit 1 and all its attachments. No judge.
All right, you can continue to defer.
Thank you, Your Honor.
Going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Does he have a criminal history?
Just a few misdemeanor, Judge. There's
Alright.
a pending MTR in County Court 14 that we still have to resolve, but it's I believe a criminal mischief.
All right. So does he have, are those the only things that he has?
I don't know the other misdemeanors. There may be 1 or 2 other misdemeanors.
All right. So this is what I'll do. Norma, can we reset this for maybe July 31st? And state, on this case, I'll need his criminal history. And then if he wants to have no harmful or injurious contact with the mother of the children and no unsupervised contact, the mother will need to appear. She can either appear by Zoom or in person.
Okay, do you mind doing it the first week of August? I'm out of town the end of the month.
Okay, what date are you asking for?
We can do that first week and I come back, Judge.
You want the week of August 7th?
Yes, Judge.
Norma, are we available for the week of August 7th?
Yes.
All right, August 7th.
That works, Judge.
All right, the court will find that the state is in compliance with discovery. Mr. Robinson, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, sure.
Next, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, Your Honor.
And just one moment. Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you understand you're charged with the offense of assault, family choking, strangulation? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, I do.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
I do.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Robinson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Very much.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
I did.
According to the plea, the state is recommending deferred adjudication. There is an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
I do.
Did you understand that to be the entirety of your plea bargain agreement? State, I'm sorry, state. Defense.
Yes, Your
I'm
Honor.
keeping you on your
I
toes.
know.
All right, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes. I do.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years. There be no contact with Belinda Robinson and the Batterers Intervention Prevention Program. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offer states exhibit 1 and all of its attachments.
No objections, Your Honor.
All right, you may continue to confirm. Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, I do.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I would just ask that you follow the plea agreement with us. The defendant has been doing therapy since this incident has occurred and has been taking AA and A classes once a week since this incident.
All right, do you have any children?
Grown children, Your Honor.
All right. Do you have any grandchildren?
I don't have grandchildren, not biological grandchildren.
All right, so you say biological grandchildren, are you in any of these grandchildren's lives?
So I have a girlfriend that has grandchildren, so spend some time with them, but not any of my own biological grandchildren.
All right, and are you living with this girlfriend?
No,
Okay. Do you have your own place? Do you live by yourself?
I have a roommate.
Okay. And so I see this started over allegations of infidelity.
It is, Your Honor.
Well, you know my rules.
I do. I've listened to it and I removed from that toxic relationship. I removed myself out of it. I've done good to get my own therapy and stay absent from Belinda. And so it's made a difference in my life already.
All right, because my feeling is that when you're in a relationship, if you think somebody is being unfaithful, you have two choices. One, you either accept it and forgive, or you say, I'm not going to forgive this, and you leave.
And we tried that and the acceptance and forgiveness part was not doable. So the next part was the obvious.
Okay. All right, this is what the court will do. The court will sentence you to 5 years deferred adjudication. Do you and Miss Robinson have any property together or anything of that nature?
No, in fact, our divorce was finalized yesterday. Ironic as it is.
Okay. No contact with Belinda. I see you have cut ties. Sometimes that's hard to do.
It's very hard.
The heartstrings still tug, but you just go through each day.
I've
So-
sat in your courtroom long enough to know, and I've listened to your rulings and your advice. I was doing it while you were talking about it, so.
Okay. But do you have an orchid?
I do.
Oh, wow. Is it surviving?
Actually, it's not, so I don't know the secret to it, but I'm told that there is a secret, yeah.
Oh, yeah. Well, we're
Actually,
working.
two of them, a purple and a white one, but neither one of them are.
Okay, this is ironic. I have a purple and a white orchid in the back. The purple one is not doing great. The white one is flourishing. So we're working, everybody, and it's funny because everybody on the staff and all of the prosecutors and defense attorneys are trying to help me with it grow. So all of the purple flowers are falling off. So we're going to see what happens.
They are different genesis, so I don't know if that has anything to do with it or not, or location, lighting, you never know.
Okay.
They're different species.
All right, so there'll be no contact with Belinda Robinson. There's an affirmative finding of family violence. The BIPP course. There's to be regular UAs, or either you can do the patch. The patch costs more, but with the patch, you just put it on and, well, they'll put it on. And then when it's time for it to be removed, you just go in. But with UAs, you have to go down on a regular basis. Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. Do one field visit. And if everything is okay, then you can discontinue it or spot check once in a while. The BIPP, I've already said the BIPP course. There is to be 100 hours of community service restitution. Or you can pay $7.25 per hour to the San Antonio Food Bank. I choose the San Antonio Food Bank because they're always running low. But if there is another charity that you would like to donate to, you're more than welcome to. But before you donate to it, make sure that it's on the list that probation has.
St. Jude's, is that on the list?
Oh, yes, you can most definitely donate to St. Jude's. So just give the information to probation. I don't want it to be an incident with George from Seinfeld where you're donating to the human fund. See, you get that, the young people don't get that, but you know what I'm saying? Yes, don't donate to the human fund, okay?
And huge aliens fan too, so I got your thing earlier with the aliens for sure.
All right. Probation, is there anything else he needs? Yes, thank you. So there'll be regular reporting by Zoom or in person. Is there anything else? Probation? All right, is there anything else you need from the court in order to be successful?
So, Your Honor, I think I've been doing a lot already, so whatever else I have to do.
All right, and I'm not gonna order the AA or NA meetings, but if you see that that's helping you, just continue to do that,
I
okay?
will. So,
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
I did, Your Honor, yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. You understand?
I do, yes.
All right, we can go off the record. Thank you for always dressing appropriately for court.
Well, thank you for recognizing it.
Yes.
You're
All right, so I want to talk about the tattoo.
Okay.
So what is the tattoo about?
Third eye.
See, I know it's the third eye, but I was wondering, is that related to the Masons? I guess I shouldn't say that out loud.
It is Illuminati. I come from a history in my family, Illuminati, so.
Okay. I was thinking we're going to do a national treasurer thing, Nicolas Cage or something.
Well, actually, through some of my therapy, I think through mindfulness and awareness, I kinda got in touch with my third eye.
All right. All right, well, good luck to you. So in this court, communication is key. If there's an issue, let probation know. If you feel like they're not addressing it, you can always come in court and speak to me.
And I think you run a very fair courtroom, Your Honor. That's been my observation, so I appreciate it.
Oh, thank you so much. You made my day. Thank you. Have a good one.
You have
Yes.
victim impact to present. The victim would like to be read for.
Okay, is she here?
She's not present.
So how do you want to present?
She sent an email.
All right, if you,
If you'd like to do it now, or we can do it.
if you,
after.
you can read it to him, or if you would like to give it to him to review.
I'd be interested in seeing it for sure.
Okay. So if you want to let him review it, but you'll need to return it to them, okay?
Okay, sure.
Yeah, of course.
Thank you.
All right, thank you. Oh, Mr. Cox?
Good. I was enjoying in 187 district.
Oh, thank you. All right, who's here on Stephen Wellington?
Aquí, Judge, I'm here. He's here.
All right, Mr. Wellington. Oh, could I see the file on Stephen Wellington, please? Good morning, Mr. Wellington. Thank you for dressing appropriately for court. I always appreciate that. All right, so Mr. Wellington, the state has filed a motion to dismiss your case and state, I see it's for missing witness. This is not a child, is it?
No,
Okay.
not a challenge.
All right, so Mr. Wellington, I'm going to sign the dismissal, but whatever brought you here today, you need to make some changes. You understand?
Yes.
Because otherwise you'll be right back here. So the state is not dismissing this case because they're saying the evidence is insufficient. They're saying that they don't have their witness. So maybe the complainant changed their mind and doesn't want to go forward. Or maybe the complainant is off living their best life somewhere. So my suggestion to you, without knowing things about this case, because nothing has been presented to me, I just know what's in the indictment. You probably should not have contact with that person. You understand?
Yes.
This case, and I'm sure your attorney told you, the range of punishment on this case is up to 20 years in prison. And if you were to go to jury trial and somebody were to find you guilty, you're looking at potentially 20 years in prison. And how old are you? 29? So you do the math. If you were to be sent to 20 years, well, I can do the math. That's easy math. That's 49 years, unless you are paroled out early. And once you get closer, the closer you get to 50, the more you're looking at the twilight of your life, unless you're planning on living past 100. You understand?
Yes.
I can say that because I'm in the twilight of my life. or Cadiz, what do they call it? The winter of your life?
All right. Approach.
Yes. Oh, whoever, thank you. And Mr. Cox, you are always dressed appropriately for court.
Always a pleasure.
All right.
I
Yes, I don't know if you have anyone else on the docket, Mr. Cox.
don't think so. We had something where we were able to resolve our differences on yesterday.
Okay. All right, thank you. All right, who's here? Laura Romero? Or Romero? And where is Laura Romero? Please come forward. Hello,
Morning, Judge.
good morning. That is your color. You know, I believe everybody has a color. I always tell Bashan and everybody this. All right, Miss Romero, thank you for dressing appropriately for court. All right. Where are we on this case? Today is the plea deadline date. So what are we doing?
We are not going to accept the plea today, Judge. We'd like
Okay.
to just set it for trial.
Okay. All right. Then we're gonna have you all. All right, Ms. Ferguson on Romero. We're gonna have you all come back at 11:30.
And Judge, I would like to say I'm not actually the attorney on this case. Sergio Ybarra is, and he is actually in Bernie right now. So
Yeah, tell him, call him, and let him know he's up for trial.
I will.
All right, thank you.
Thank you. Maybe we be excused, Judge.
Yes, but be back here at 11:30.
Yes, Judge.
Okay, thank you. Jose Ramirez. Who's the attorney on Jose Ramirez? Hi, and if I could have Jose Ramirez come down, please. Yes, I'm telling you, everybody's just wearing their colors that make them pop.
Thank you.
All right, what is happening with this case?
The state needs more time. They want to re-interview the complaining witness and they're missing some CPS records.
Okay, so discovery is CPS records. Anything else that's missing?
To my knowledge, no.
All right, who is the prosecutor on this case? It's family violence. It's Jose Ramirez. Oh, that's okay.
Hang on. We'll talk.
Yes.
Okay, and that's your color too, Brittany. Everybody's just wearing their colors. All right. So counsel is telling me that CPS records are missing.
So it's unclear. There was a request done pre-indictment, a grand jury subpoena pre-indictment for the CPS records. They're not in the file. However, I was reviewing the police reports and it looks like there was, the detective had talked to the mom and the mom said CPS was not involved. So I don't know if there are any records, but we have not, there's nothing in the file indicating that CPS told us either way.
Okay, and then also, I'm being told that you need to talk to the complainant.
We do, yes.
All right, Ms. Ferguson. On Jose Ramirez, can I have a 45-day reset, please?
Is this for discovery?
Yes.
I'll do August 31st.
All right, so we're gonna come back on August 31st. What's gonna be due on August 31st is the discovery. And state, will you be prepared to make an offer at that time?
Yes.
Okay. All right, is there anything else, counsel?
Nothing from defense, Judge.
All right, once you all sign the reset form, you're excused.
Thank you.
You're welcome.
Here you go.
Anna, do you see Jose Ramirez on the docket?
He's on the page 14.
All right, thank you. All right, who is here on Betty Jean Gonzalez? All right. So you all ready to proceed?
Yes, Judge. Sitting on the right side, right, Judge?
Hmm?
I'm sitting on the correct side?
Yes, you are.
Sure.
Oh, and congratulations on the baby. She's such a cutie pie.
My gosh, Judge, my first two, brown,
Mhm.
brown eyes, whole way through.
Mhm.
My wife's got green.
Mhm.
I've been, but this little girl, if you take my wife's green eyes and then you take a little bit lighter shade of my brown
Mhm.
and you overlay them, that's my daughter's eye. Right. now.
Aw,
Like that jungle green.
yes.
I don't know if it's gonna fade though.
You're like praying, please don't let it fade.
I'm like, please don't let it fade. At the same time though, dark green eyes with my skin color, I'm gonna have to fight. I'm gonna have to get shotgun light.
People will ask questions like, where are the dark green eyes coming from? And then she can tell everybody. But she is a cutie pie. It's hard to believe it's been a month.
You're telling me, Judge.
Time goes fast.
Yeah, especially when you're not getting any sleep.
Yeah,
Goes by real fast.
she's running the household. That's awesome.
Oh, yeah.
All right, court is going to call 2022 CR 9686B, State of Texas versus Betty Jean Gonzalez, AKA Betty Jean Gonzalez, one with the Z, one with an S. All right, could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Jump as for defense.
And are you Miss Gonzalez?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Okay. Are you saying Betty Jean Gonzalez, who was placed on deferred adjudication in 2022 CR 9686B for the offense of possession of a controlled substance penalty group 1, 4 grams to 200 grams on February 2nd, 2023 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
Yes, ma'am. Violated condition number 1, on or about the 6th day of May, 2023 in Bexar County, Texas. The defendant, Betty Jean Gonzalez, AKA Betty Jean Gonzalez, committed the offense of possession controlled substance penalty group 1 in violation of condition number 1. And actually, Judge, if I could make an oral amendment to this, this doesn't allege the amount, but it should be possession.
Oh,
of-
you don't need to
Oh, okay.
put the amount in, counsel.
Okay, sorry, Judge.
Oh, no, no problem.
And we waive the other violations.
All right, to violation of condition number 1, how do you plead, true or not true?
True.
And with regards to the state's waivers, defense, do you have any objection?
No objections, Judge.
All right, did you understand by pleading the violation of condition number 1, the court could find it true, grant the motion, find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Judge. I've spoken to defense counsel and Deshaun with probation, and we'd like to refer the defendant to felony drug court, Judge. And if she's not accepted in the felony drug court, we'd like her to go to inpatient. Either SATIF or SAFE, Judge.
All right, defense, is that the agreement?
It is, Judge.
All right, Ms. Gonzalez, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Would you state your name for the record?
Betty Jean Gonzalez.
All right. So, Ms. Gonzalez, you know yourself better than I do, better than your attorney does, and better than probation does. If you want the treatment and you have a drug problem, I will most definitely refer you. I'll deny the motion, refer you to felony drug court. If felony drug court doesn't accept you, then you will be accepted into an inpatient treatment facility. But you know whether you can do this or not. Now, with the amount of drugs you had, even though it was reduced to possession, felony drug court may not accept you. And that's based upon the amount of drugs you have. Do you understand?
Yes, ma'am.
Now, so I can do that, or if you would like, I can revoke you and I will sentence you to 4 years in the prison. So it's completely up to you. When people want help, I want to give them help. I want people to do better. I note that you have people in your life, probably young people in your life, because I ordered parenting classes for you. But if you're not ready to take the help and ready to really work hard, because you're going to have to work really hard to maintain your sobriety, to not pick up any more cases. And I know with the possession less than, with a possession penalty group 1, I know the only difference between that case that you have and not having it is the fact that you didn't get a chance to use it. So I understand that. So what would you like to do? If you would like to discuss it with your attorney, you can, but you know yourself better than I do and he does.
I do need the help.
All
I
right.
really do want the help.
So you want the help?
Yes, ma'am.
All right. So I'm going to give you the help, but you're going to have to make better decisions. When things happen in your life, the go-to can't be, I'm going to go out and get drugs, because otherwise what's going to end up happening is you're going to have another case and you're going to be back before me. You understand?
Yes, ma'am.
All right. The court will deny the motion, alter and amend conditions to do a referral to felony drug court. If not accepted, then inpatient treatment, either at, if probation, if you're recommending SATA for safety, all right, that'll be SATA. And if SATA doesn't accept her, then it will be ISF, cognitive and substantive track. And this is to happen while in custody. If you are accepted in felony drug court will be the person that is over your probation. The only time you'll come back to me is if you are unsuccessful, or if you're coming back to me asking me to appear at your graduation.
Yes,
And
ma'am.
I always, if I'm in town, I will be at your graduation, okay?
Yes, ma'am.
All right. Thank you. And state is dismissing the other charge. There you go. All right. Is there anything else?
Nothing from the defense counsel.
Probation, is there anything else she needs? All right. Thank you. Good luck.
Thank you. Excuse.
Yes. Who's there? Lionel Young?
Morning, Your Honor.
Good morning. And Mr. Young?
Mr. Young's down in the basement, Your Honor.
Oh, what is he doing in the basement?
Your Honor, just so you know, we didn't bring him up yet. He was found competent last week. I just got a offer on him. I'd like to talk to him about that offer over the next week or so. If we can get one reset in this matter.
Okay, so is there a reason was he just found competent in the basement?
No, Your Honor, he was found competent last week.
Okay, so why isn't he?
I told him I didn't think he needed to be brought up.
Oh,
I asked him
Yeah.
and he said.
You-
all
I said
right,
I didn't
yes.
think he needed
If you can bring, are you able to bring him up? They'll bring him up, then
Okay.
we'll take him up.
I'm gonna step right across the 187 judge. I was speaking to 379. I'll be
Okay.
right back.
All right, thank you.
It's just that we have too many inmates right now.
All right, so we'll take care of it as it comes, okay? Daniel Swingel. Hello, Mr. Otisdorf. How you doing this morning?
Pretty good, pretty good.
Okay, and Mr. Otisdorf, you're on this side.
Oh, yes, ma'am. Let me do that.
All right, are you ready to proceed on this, Mr. Otisdorf? All right, court is calling 2020 CR 4185 State of Texas versus Daniel Antonio Swingel. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Jim Oltersdorf and Mr. Swindell.
Are you Mr. Swingel?
Yes, ma'am.
Is that how you pronounce your last name? Swingle, okay. All right, Mr. Swingle, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you have a chance to review those documents with your attorney and did you understand them?
Yes, ma'am.
Are you the same Daniel Anthony Swingle,
Yes, ma'am.
who was placed on deferred adjudication in 2020 CR 4185 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on June 5th, 2020 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bexar County, Texas, the defendant, Daniel Antonio Swingill, did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, December 2021, January, February, March, April, May, June, July, August, September, October, November, and December 2022, and January, February, March, April, May 2023 in violation of condition number 5.
All right, how do you plead to that? Guilty?
Guilty.
I'm sorry, true or not true? No, the reason what is throwing me off is I just looked at this and I saw that this came from, I think this came from the 290th because Jennifer Pena is listed. So I guess it got transferred here. I'm sorry. How do you plead to that? True or not true?
True. Your Honor, state waives all the violations.
All right. Any objections?
No, Your Honor.
All right, Mr. Swingle.
Swingill.
Swingle.
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 Oh,
Okay. Mr. Swingle, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Your Honor. The agreement is for 2 years TDC. The state's also going to take into consideration it's a misdemeanor cause number. I don't have that misdemeanor cause number right in front of me, but I think Hank is going to write up the dismissal right now.
All right, is that the agreement?
It is, Judge. Maybe if we can be heard at some point.
Yes, you can be.
Well, you're probably concerned about that assault. It's refreshingly 2 males. My client basically got into a fight at the jail, so it's not a male and a female, which is good to know. I haven't had one of those for probably a year. Again, hasn't been good at all about reporting, but his record is not bad at all. That's why the state has presented a recommendation to you of 2.
Okay.
We realize, and Mr. Swingill realizes and is concerned over the fact that he's on deferred and full range is punishment is available to the court. So we're deeply concerned about that, but we're hoping that the court will follow that recommendation. Again, we've examined, both myself and the DA examined his record. It's not bad. When he was arrested again this time, he didn't resist, he didn't evade, he didn't do anything that would cause any problems. He wasn't caught shoplifting, for example. So we're just hoping the court will go along with the 2.
Okay. Mr. Swingill, is there anything you wish to say?
Yeah, I got 5 kids, so
5 children. Remember, kids are baby goats.
yeah, I got 5 kids. I got a wife.
5 children.
5 children.
Yes.
5 children I'm trying to go home to and just working hard to change my life. Really am.
Okay. All right, the court will follow the agreement, sentence you to 2 years in the prison, give you credit for any time served. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. You understand?
Yes, ma'am.
All right, we can go off the record. So were the tattoos painful?
No, I mean, the side of my arm was because I got the scar right here, so, but not really.
Are you going to get
I
any
didn't
more?
hurt the most.
All right. Oh, and why did you do that?
I don't know.
All right, so you have a felony conviction. I'm sure your attorney has told you now, if you were to pick up any more criminal cases, you would be known as a repeater, which means whatever level felony that is, the punishment range would increase by 1 level. You understand?
Yes, ma'am.
You say you have 5 children, then you need to do better by them. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you for hearing us.
Thank you. Who's here? Nathan Martinez?
Hello.
Hello, everybody's just wearing colors that are pop, making them pop. You know?
Well, you know me, I love,
Yes,
I went to school in New Orleans, I love bright colors. And
you have to.
this is the city with Fiesta.
Oh, there you are.
My client wore bright colors as well, Judge, as you
Oh,
can see.
awesome.
Yes.
So what are we here for?
Judge, I confirmed with probation earlier, and apparently because of some past affiliations, he's not eligible to go to ISF or DDRF.
Mhm.
And so there was going to be a recommendation of sending him to ISF,
Okay,
state ISF. And Judge, just to let you know, my client's been in for nearly a year and in the county jail. More recently, though, he just learned that his 11-year-old daughter there's a CPS investigation going on involving the daughter that another man might have touched her inappropriately, done some things. So my client is very upset about that, as you can imagine, and is asking if there's any chance he could be out at least for a little while to try to see his daughter and be with her while this is going on.
right. Well, one, I need proof of the CPS case. Oh, look, he came prepared.
Right, I'm just learning of this morning too, so.
Oh, well, Mr. Kuntz, if you want to look at it and review it and
It's.
okay. Thank you.
Thank you.
All right, probation, are you aware of the open CPS case? All right, and I'm assuming that this is involving someone other than your client.
Correct, Judge. It's apparently his daughter has a sister that is not his biological child. And it's the father of that child that's accused of perhaps being inappropriate with his daughter, right?
Yes. All right. So probation, he was waiting for transfer for drug treatment.
Your Honor, so he was ineligible for DDRF or any of our local facilities due to previous involvement in a gang.
Mhm.
So the tap was it was redone and they are now requesting state ISF.
All right. And so I see where he pled on this case, May 23rd.
Was sentenced probably May 23rd, right?
Yes.
Yes.
And what is the wait time for the ISF?
Your Honor, the wait time is going to be approximately 30 days.
Okay. And we're sending to ISF because of mental health issues or?
State ISF will address any substance abuse or mental health issues.
All right, let me see if I can.
And Judge, from my perspective, having known my client now for some time and representing him, he has struggled with substance issues for some time. And in fact, every arrest he's ever had has been as a result of substances. And so for his long-term well-being, I think he does need counseling, whether that's outpatient or inpatient. My client would obviously ask for outpatient right now.
What is his criminal history? Because I don't have that.
Your Honor, on your court summary on page,
Okay, let me
I think
see.
it begins on page 2 and goes on to page
That
3.
one I don't have. No, I have.
Under it's going to be under SR, the SRs.
Okay, thank you. Let me go to SR. And which page did you say?
Go to page 2 and page 3. You do have probably 2 Martinez's.
Yes, I do. Okay. So I can't send him to felony drug court. He's already been denied.
Judge, refresh my memory, was he denied because of the prior gang affiliation?
Yes.
Okay. That's what I thought.
All right, this is what I'll do. I will have him sent to ISF defense if you want to talk to felony drug court and explain about the gang affiliation, whether he's still in it or not. You're more than welcome to do that. And if you're able to have felony drug court accept him, then that's fine. But I'm going to recommend then that he go to ISF. And the reason why, Mr. Martinez, you do have a drug issue, because I never would have recommended you for felony drug court if you didn't. And this whole child protective service case that you have, I've done plenty of those. I think your attorney has experience with those as well. Regardless of what's happening, they're going to want you to have treatment too. And sometimes you're on better footing if you have treatment. They're not going to terminate your rights normally if it's because you're in inpatient treatment. You understand?
Yes, I was just worried about if her mother was gonna continue to have custody of her, and if she wasn't, then I don't know. I don't really know what's going on. I'm in the dark about all this, so.
Well, normally you should have an attorney on that side if they're opening up a legal case. And what they will do is, even though you're in custody, they're supposed to actually have you brought over, have you by Zoom for any hearings that they have. And if you have an attorney for you over there appointed to you, they're supposed to come see you. Okay. But normally in cases, I don't know the specifics of yours, but normally in CPS cases, what ends up happening with those type of charges, they do their investigation. They will ask both parents if they have someone that the child can be placed with. Because if those allegations are to be found true, normally they don't place the child back with the parents until after a service plan has been completed, and they think that all of the dangers have been alleviated. Sometimes in cases like that, they may return the child to the parent who had the child when the allegations are alleged to have happened, but they'll only do that normally if the person who's accused of committing the offenses are out of the house and that person has no more contact with them. Okay.
And I think one of my conditions was I wasn't able to have like any kind of custody of her. I think, or if I heard wrong, I don't know if I heard wrong.
I'm sure there may be no contact, but your attorney will be able to speak to you about that. And that's something that if you are completing your service plan, if there is a service plan that results from this, your attorney can always come in and ask for different conditions to be changed.
Okay.
All right. Is there anything
There are
else?
no contact orders as a result of this case that he's on?
I
probation?
don't think so.
I don't believe so either.
Let me see what I've written. There are no contacts with several people. And probation will be able to tell you the names of those people. I believe this is a Pizzuto and a Sanchez, but they'll be able to give you the exact names.
Okay, so he's good. Thank you, Judge.
All right, thank you. So we'll do probation. He's to remain in custody. We'll do the state ISF. And counsel, if you want to talk to felony drug court and explain and see if they'll accept him. If they do, then he can go to felony drug court if they accept him.
Okay, I'll make one more.
Both tracks, the substance and cognitive.
Yes. All right, is there anything else?
No, Judge, I'll make one more pass at drug court.
Okay,
Thank you.
you're welcome.
What started as a routine criminal court docket turned into a powerful reminder that every defendant's future can change with a single decision. Throughout the hearing, the judge handled case after case, making sure every defendant understood their rights before making life-changing choices. Some cases were delayed because attorneys needed more time, while others moved forward with plea agreements and trial dates. But the most emotional moment came when a woman facing a probation violation stood before the court. She had been charged with another drug offense while already on deferred adjudication. Under the law, the judge had the authority to revoke her probation and send her to prison for years. Instead of rushing to punishment, the judge asked the most important question. Do you truly want help? The judge explained that there were only two paths